We now go to item number 5. This is Presidential Decisions Policy for the Appeals Committee. Excuse me.
Good morning, Mr. Chairman. I see some of the members of the Appeals Committee are here today on this committee. In fact, Ms. Hendricks and Ms. Dumont, and then Ms. Dillon is here as well. So they've already seen this before. I want to begin with also introducing Senior Staff Counsel Carolyn Kubish, who has helped me with the research on this and helped present it at the November 2012 Appeals Committee. So CalSTRS uses the Administrative Procedures Act for administrative hearings involving appeals of benefit determinations. And the CalSTRS Appeals Committee has been delegated the specific authority to act on those proposed decisions from administrative law judges. Often, the CalSTRS Appeals Committee and staff see the same issues and the same laws coming before it. And a lot of times from the administrative law judges, we get inconsistent decisions on the same facts and law. There is a need to provide guidance to our members as well as to reduce these inconsistent decisions. And the Administrative Procedures Act contains a provision that allows agencies to designate decisions or any part of a decision as precedential. And once designated, it becomes binding in future administrative hearings. I've included a copy of the law on page 51 of the materials. It's the government code section. Other agencies such as CalPERS, the State Personnel Board, the Alcohol Beverage Control Board use precedential decisions frequently. Our appeals committee here at CalSTRS has not been delegated this authority, and CalSTRS has not designated any decisions as precedential. In November of 2012, the appeals committee considered this item and after a robust discussion, approved the language in attachments 2 and 3 and recommended that this item move forward. So it would require a change to the board policy, which would authorize the designation of precedential decisions, and then it would authorize an amendment to the appeals committee charter, which would give them the express authority to designate any part or all of a administratively adjudicated decision as precedential. So the next steps would be to get this committee's input on both the board policy language as well as the committee charter, and then move forward and recommend that the board adopt the changes to both its policy and to the charter. And the reason it's before this committee is because the Board Governance Committee has the authority in its charter to recommend the roles and responsibilities of the various board committees.
So John, can you help me, as a member of the Appeals Committee, walk through the practicality of having this authority to use a precedential decision in making future decisions on the Appeals Committee in terms of, I recognize it's for efficiency, consistency, predictability, but how does us having this authority impact the ALJ's decisions? Sorry. How does that interface with when we're meeting as an appeals committee and we have a recommendation from the ALJ? How does this interface with that in a practical sense when we're considering a case?
Okay, it would help us when we file a statement of issues in an administrative hearing. So before you ever hear it, if you've already designated a previous decision on the same issues, the same law, as precedential, we would attach a copy of that to our statement of issues for the court to instruct the court, the administrative law judge. I refer to that as the court. I'm using that term interchangeably here, but it's the administrative hearing, to notify them that this issue has already been decided as a precedential decision, in which case it's binding on an administrative law judge, a subsequent administrative law judge.
So the benefit of that is it helps the ALJ, before we even hear it on the committee, it helps them say, oh, the CalSTRS has dealt with this before, and that helps with the consistency piece. Is that what you're saying?
Correct.
It doesn't necessarily have to influence the ALJ's decision, but it can give them a sense of there's been this case that's come before, and that can help inform their decision.
Oh, no, it's actually a binding precedent. And the difference is that the ALJs, administrative law judges, are in the same branch of government as we are. They're in the executive branch, as opposed to the judicial branch of government, Superior Court, Courts of Appeal. Now, it's not, the appeals committee, if they're delegated the authority, could remove their designation of precedent. You're not bound by it. You can remove it or designate all of the decision, a part of the decision. It's up to the committee. It's just to help efficiency. It's helped to prevent inconsistencies is the main thing.
It's binding for the ALJ, but it's not binding for the appeals committee. Is that what you're saying?
Correct. You can remove the designation as such. Correct.
So when we're considering a case, we can say there's precedence, but we have a different decision, or we're
Correct.
making it different. But the ALJ can't do that.
Correct.
Okay, thanks.
It would be similar, it's just part of the regulatory process. You can either go and adopt a regulation pursuant to the Administrative Procedures Act. When you designate a decision as precedential, that's exempt from that process. So.
John, could I clarify? There was something in Sharon's question that I wasn't sure. If the precedential decision is in place at the time that a particular appeal comes before the appeals committee, can the appeals committee choose not to follow the precedential decision, or does it require deselecting it, decertifying it as a precedential decision before it can be ignored?
It would require decertification or de-designation before you.
So what does that look like when we have an appeals committee, right?
Right.
And something comes before us, and there's precedence, or, and then do we have to, as a committee, decertify it and then come back to that conversation in another board meeting? Or can we do it right there, or?
That's something we would have to work out with the policy. Certainly an action item like that would require it to be on the agenda ahead of time. And the way we would work this policy is that when a decision comes in, the CalSTRS has 100 days to act on it, or it's automatically adopted. So there's a process in place for that, and we go through with Peggy Plett staff or Robin staff or the staff to see, is this a decision we're going to recommend it be adopted? Is there a precedent in place? What needs to be done with that? So that's something that we'd work out in the policy. But we would envision if we had a decision that we would recommend you adopt that was also governed, that had not yet been designated as precedent, we would put it on the agenda that not only are we recommending you adopt the decision, but then also adopt it as precedential, so that going forward, people can show up at the hearing and go, well, I agree you should adopt the decision in this case, but I don't think it's precedential. You'd have that time to argue it.
100-day.
Correct.
timeline. Okay.
And if it was one you had previously designated, that would have to make a recommendation to bring that, on the agenda to come forward and say you want to reconsider your decision to designate that case as precedential.
Okay.
Michelle?
So I have three things, but I think you answered the second one. The first was if you could just walk us through what it would take, in practicality after we agree to make it a precedential decision. What are your next steps? Like, how's that work? And so the other question was what does it take to rescind the designation? But it seems pretty easy, but maybe I'm misunderstanding how you responded to that question. And the third piece was about it being binding, and it kind of gives a set of givens for the ALJ. That's how I sort of perceived it, is given this precedential decision, these are the other things you have to sort of work with. But as the appeals committee, if we felt that the facts of a particular member's circumstances were beyond the scope of the precedential decision, or we didn't necessarily agree with the outcome, even based on the precedential decision, we could send it back to the ALJ, right? We could not adopt the proposed decision and send it back for additional information or for further review based on other circumstances that might not be covered by the precedent. Is that still the case? Will we have that leeway? Oh, and I did have one more piece. I'm sorry. And the last piece was whether or not, if we were to adopt it as a precedential decision during that appeals committee. Currently, our committee reports are just adopted during our board meeting. But if we were to take that extra step of such additional scope, would we then vote on vote on that as a full board as well?
I can answer the last question first, just because it's the freshest, the freshest one in my mind. What we're recommending with the charter is that the appeals committee would be delegated the authority, the sole authority, to designate a decision as precedential. So the board the board now has that power now, but we're asking the board to designate that authority to the appeals committee. So you would not need to seek additional board approval of that action if you took it. The question of what do you do with a proposed decision when you get it, if there's a precedential decision on it or not, there's 5 things the appeals committee can do with the decision. 3 are adopt and 2 are reject. So you can adopt as is, you can adopt and make technical changes, typographical errors, miscitings, or you can mitigate a fee, which we don't have, or a fine. Or you can reject the matter and send it back to the ALJ to take additional evidence, not just information, but evidence. Or you can reject the matter and hear it yourself based on the record, based on additional evidence, whatever you choose. And you wouldn't lose that power. That's in the statute as well. So if there was a decision, I'm just envisioning, and you have your own separate counsel that can advise you on the law on that, on a specific case. What I would envision is if there was a decision from an ALJ that was based on a previously decision that's been precedential, and if the committee did not agree with that, one option for it would be to reject that decision and send it back for additional evidence based on whatever your concerns were, or to rehear the matter itself. Does that? And then you had so the process would be if we got a decision in, we would, or a piece of a decision, we would analyze it. We would meet with the benefits and services areas, and we would decide whether it had good facts, good law. Bad facts make bad law. We don't want just any decision as precedential that we agree with. We want it to be one that's going to likely to recur. So we have to carefully analyze the facts and the law as it's applied. And then we would make the recommendation to the appeals committee to not only adopt the decision itself, but then adopt it as precedential. Additionally, it's any decision after July 1st, 1997, so there may have been a decision from a couple of years ago that's really good, that we think would make a good precedent, that we could bring before the committee as well. So it's not just recent. The law allows us any decision that's after July 1st, 1997. So that's 16 years, or almost 16 years now. I'm not aware of any off the top of my head, from 16 years ago. But what I mean to say is that it wouldn't be any decision that's issued after this policy is adopted. It could be any decision going back to July 1st, 1997.
Excuse me, I don't see any other, Nancy?
Just a few questions, and maybe everybody doesn't see a problem with it, but I was just curious about something. On page 49, we're talking about this mechanism would give CalSTRS the ability to use a previous court ruling. And then when we look on page 55, number 2, the red highlighted thing says administratively adjudicated, and I wasn't sure whether it was a court decision that could be a precedent or an administrative adjudication, or both.
It would be an administrative adjudication. I think I mentioned that earlier. I was using that term mistakenly here interchangeably,
okay.
but it is it's only the administrative decisions. It's only the decisions from the ALJs.
Okay, and then just a couple other things. We started off by saying that, this is to help members so they know, what the board sees as a precedent. And the statute says that this list of the precedent decisions should be updated no less frequently than annually. And it just seemed to me to be really helpful to the members. You wouldn't wait annually to do it. I don't think it would be a big burden to do it as soon as you did it. I mean, you decide one month that this is going to be a precedent decision, then, maybe that could make it onto the website, or it would be more helpful, it just seemed to me. And then my other comment was, well, actually, I have a couple more. I don't know how many policies that we have. I'm now looking at page 53. I don't know how many policies we have where we're naming a specific individual on staff that is to make a recommendation other than the CEO and the CIO. And, not that you're going to get hit by a bus tomorrow, but it seemed to me if somebody was taking your place, would it be better just to say the legal department, or is there a reason not to say the legal department because of the dual role that the legal department has? So that was one question about just that the assistant general counsel being sort of named. And then I thought maybe we could just, maybe a little more artfully write the third paragraph. I don't think we need policies that say that a statement should end with a colon and then specify. I think we can just say it should clearly state whether the whole decision's a precedent or part of it. I don't think we have to get that specific on whether there's a colon followed by something at the bottom of the page. And then the last point, and then I'll be quiet, is on page 56. It kind of worried me a little bit. Bottom of page 55, this is a responsibility of the appeals committee, which means it's something you have to do. It's not you may do it, you have to do it. So it's a responsibility of the appeals committee. And then on page 56, to hear, deliberate upon, and expeditiously decide to designate whether something is a precedent. And I guess I would just say it's their responsibility to decide what adjudicative outcomes are to be a precedent decision, because I don't think you want to say they should have to do it expeditiously. You might think it's a one-off thing, and you say, we're never going to see this again, and then it comes back, and it's like, oh, we saw it the second time, and then it comes back the third time. You might say, hey, we better make this a precedent decision. We've seen it 3 times now. And I think that the plaintiff's lawyers could actually cause a little bit of trouble if this language is in there and you waited to see it 3 times before you just said it's a precedent. So I would just say to decide what decisions should be a precedent decision. And so, not that you have to expeditiously do it and that.
I'd like to, if I may, address some of these issues that Nancy raised. Okay.
Nancy, can you just, I didn't totally understand what you just said. So can you kind of, I don't know, translate number 2 into, I didn't understand the difference of like taking out expeditiously and what the impact is on our role in the appeals committee. So could you maybe just kind of reiterate how you think that should be stated, and then what is our responsibility then as an appeals committee person?
I think it would make sense to say your responsibility is to decide what adjudications should be a precedent decision. Take out all the you got to do it expeditiously, only because I just think that you may not know that you want to make something a precedent because you think it's a one-off thing, and then you see it 3 times, and then you go, holy cow, we should make this a precedent so we don't have to keep arguing this. And I just don't want you to be in the position of you didn't do it expeditiously. You saw it 3 times before you took any action on it.
But isn't not making it a precedent a decision in and of itself? If you, yeah, I mean, I'm not a member of the appeals committee. I've never not seen them in action. But if they rule on a particular matter and do not determine that it should be used as precedent, isn't that a decision?
It doesn't, then you haven't deliberated upon it, I would say. You were just silent on it. I wouldn't say that was a conscious decision. Because you're not deliberating, you're making a decision about a particular person's case, but you're not deliberating on whether that should be a precedent. I think it's the responsibility of the appeals committee to do it. I just worry about all this extra language that's around it.
And expeditiously, that part.
I don't think it's necessary, and I'm just afraid somebody would say you weren't expeditious in doing this.
As that last point, yeah, I don't, whether or not you do it expeditiously and whether or not that's grounds for somebody to challenge you, that's, if you want us to take it out, that's fine. But I do think that we need to remind ourselves of the fact that this is done anywhere that this agency of the state or is performing a quasi-judicial function, that the judicial, the judges, if you will, see the same cases over and over again or see some of the same issues. But the consideration of whether or not something should be precedential is something that's recommended to them by the agency. And that's why the Assistant General Counsel is in there. It's not John, it's whoever the Assistant General Counsel is, because under our the way that we operate, the Assistant General Counsel is the staff member assigned to the committee and is the advocate for the system. That's why we have independent counsel for the Appeals Committee. So the purpose of having this done is to be delivered, in other words, have it analyzed, how it will work within the procedural guidelines, the APA guidelines, how this would be affected, what language should be in the precedential decision and what should not. And I've seen this in other agencies where there may just be a paragraph. So it may be where the administrative law judge considered one specific legal issue that the agency wants to adopt as precedential, and everything else is deleted. And that's okay. And many state agencies have an entire list of these precedential decisions that allow people to go in and interpret how the law is going to be provided in a particular circumstances. So my concern is that the Appeals Committee gets a package with a recommendation that they consider and vote on. My other concern is that there would be some sort of expression from the judges to prejudge a case. So if the precedential decision is, so if there's something pending before the Appeals Committee and the Appeals Committee says this should be a precedential decision, that there's a prejudgment if another case comes along, as opposed to the nuance of saying, we think the system should look at this and make a recommendation as to whether or not this is a precedential decision. I do think that there has to be a process to go through, and that's kind of the way we created it, was to have a fulcrum. So the fulcrum would be the Assistant General Counsel or the CalSTRS counsel to present this, because CalSTRS as the agency is given great deference within the administrative adjudicative process, and that's actually a specific legal concept that's very much recognized. And so what you're really saying is the agency is interpreting this statute or this rule to mean this, and the administrative law judge has to follow the agency's interpretation of its own statute. So there is a separation of functions there between the judge and the system, and navigating that without having a complete, because every member of the board is considered to be a judge, navigating that without blending those two roles is difficult, because we don't really have an objective person to designate, in other words, make the final decision. And so what we want to do is make it as objective as possible. And what I mean by that is there's nobody outside the Appeals Committee or outside the board who can then say, okay, well, we've got staff's recommendation, we have the recommendation, and we objectively say this should be a precedential decision. But we want to create as much transparency and as much objectivity as possible, which is why the separation of roles is integral to the process.
Comment based on our previous conversation. I know just for this board member, and I think, Nancy, your clarification on the responsibilities, again, I guess I would ask for staff, as we have consider these policies, I just think straightforward and less is more, and more direct language that just is simplistically kind of outlined. I recognize in the legal world that that's not always able to be the case, but I think, as you, Nancy, give feedback on number 2 of the responsibilities, and just to say our job is to decide about these administratively adjudicated decisions, that to me just has, I just think in general, the more direct and more concise and more simplistic we can make our language so that it's clear for board members what our responsibility is, it's clear for the public as they read our notes. And again, I recognize, I'm not a lawyer, so I recognize there's some degree of more words are important for the legal ramifications. But so I guess that's, even as you're talking, Brian, it feels like sometimes the words get a little convoluted. So the more straightforward we can be and directive we can be about what are we supposed to do on this committee? What's our responsibility? 1, 2, 3, let's do it. And I guess I would I would encourage maybe for that number 2 to be more clear, more direct about what our responsibility is. I think Nancy's comments are well taken, and so I would encourage an edited version of that that's a little more straightforward and simplistic.
Michelle?
I was just going to the expeditiously, the expeditious thing. And I guess I had given that word more leeway maybe than, because I saw it and I was a little concerned, but I still thought we would have the leeway to, because it is a recommendation being brought to us, to separate that out if need be. Say we'd like to check with the Benefits and Services Committee because this is an issue that's come up 3 or 4 times, and maybe it's a policy, it's a different type of policy decision we need to be considering, not necessarily just, for the appeals as well. And so I guess I would just hope that expeditious would still provide for not needing to make a binding decision at that moment, but having the opportunity, since we can go back years and years and pull it back to consider it as precedential, that we would have that leeway as well. So that would just be my hope, that we could incorporate that into it.
Go ahead.
So on that comment, so there's no time limit except for the July 1st, 1997 date to designate something as precedential or not. The 100-day time limit is only whether to act on the ALJ's initial decision. Right, so that's where that, correct. You could, and that's up to you, or you could not, you could adopt the decision from the ALJ, but not our recommendation to make it a precedent. I mean, that would be up to the committee, and receiving advice from its independent counsel. There was another question on the annual update. If we don't designate any, if we've designated one case as precedential and then for 2 or 3 years we haven't, we could update the online database to say this is current as of, even if we haven't updated something in 2 years, we could say every January 1st or whatever, this is updated, this is accurate as of January 1st, 2013. Just to let people know that we have looked at this.
But I think Nancy's point was that if you have a new precedent every month, you shouldn't wait a year to put it on the
Because
database.
a lawyer can come back. and
There's,
say it's
the law just requires not less than annually. You could do it every time you adopt one. I mean, it's really it's a process issue. It's not really illegal.
Grant?
We would want to do it as soon as possible
That should
because
be expeditious.
Yes.
the purpose is to
hard to
provide
say.
guidance to members.
Right.
Thank you. I was just just wondering if we could actually get rid of number 2. The first one under the responsibilities is here, deliberate upon and decide. And it seems like part of the decision is what's the outcome and whether it's going to be precedential or not. And I don't know if that would
I love that.
alleviate your concerns.
Thank you, Grant.
So you would recommend merging 2 into 1? Is that
Or just leave one as is. The authority above that says that the board or the committee does have the authority to make a decision precedential.
Are you?
If you have the authority, why do you have to have it in the responsibility?
Two things. I actually think it's important to have number 2 there. I would modify it to make it clear that it's expeditiously decide on, basically decide on council's recommendation, act on council's recommendation. If council doesn't recommend that something be precedential, there's nothing to do. But if they do recommend that it's going to be precedential, I think it's up to the appeals committee to say yes or no within some limited period of time. And you can say no and come back later on and say yes, but I don't know what you guys do. I keep saying that. But this is.
I was just gonna say, come
I
today.
can come watch today.
We
But-
have a
but-
meeting.
But, in my day job, the area that was closest to this was IRS rulings. And they had 2 sets. There were private letter rulings that had no precedential value whatsoever. The bottom of the letter said, this cannot be used as precedent, meaning that the IRS could take the exact same facts and come up with a totally different conclusion. And you could show 1,000 different letters that said this, but it didn't matter. They could change their minds at any point in time, and it didn't matter. And then they had private letter rulings. that did have precedential value. And these rulings were, the IRS would bound itself until it decided not to bind itself. And so and so there were fewer private letter rulings than there were, I mean, there were more private letter rulings than there were published opinion letters. And so what we're setting up here is an appeals committee that will have rulings on individual cases that have no precedential value, and then a set of opinion letters that do, that will bind everybody below you, that you should take more time with, be more deliberative with, think through the consequences of the impact of this on a whole class of people. And you should take more time and grill the Assistant General Counsel and as to why this should be the case, and quite frankly, accept comment from advocates for on the other side before you make your deliberations. Which is why I'm pleased that you're saying this wouldn't happen without an agendized item, so that the public would know that we're considering making a portion of a decision that was rendered in 1999 a precedent, so that members of the public can come in and give you input on that. But I think once you do that, I'm not bothered by the expeditious standard in terms of making a decision on what the recommendation is. Now, I say that born out of my own frustration with the IRS that would have memorandums from their general counsel on something, and they would take years and say, we don't know what we want to do with this thing. And years would go by and they wouldn't say anything. You can do that too if you want to, and take out the word expeditiously, and you can just let the Assistant General Counsel's recommendation sit there, and it's for what it's worth. That would be my recommendation as chair of the governance committee. I'm not wedded to that, and I will gladly accept your input from this. But quite frankly, I am concerned that hearing from members of the appeals committee, I want that committee the members of that committee to have a better understanding of what this means than I'm hearing now, what their responsibilities will be if we adopt this. I like the policy as it is. I'm comfortable with it, but I am willing, if the members of the appeals committee who are here so desire, to give them some additional time to get a better feel of what their responsibilities will be under this before we finalize the terms under which they will be acting. Ms. Dillon.
Nancy, I understand your concern about the expeditiously, and I'm hearing Michael's concerns that we need to really make sure we get this right. And so I'm totally comfortable taking out the expeditiously, but leaving the remainder of the number 2 in. But I do have a question for you, John. You know, there's been times that we've been in appeals and we notice a pattern. How the policy is written is that the only trigger to take a look at whether it ought to be set for precedent or not is upon recommendation from the Assistant General Counsel. But there are times that the committee itself starts to see a trend, could the committee then ask the Assistant General Counsel to take a look at whether this ought to be set for precedent? And so that there's actually a trigger coming from the committee itself for further research and then a recommendation?
Absolutely.
Okay.
And there's a nuance there that I know Mr. Lawson probably gets as an attorney, and Brian tried to explain, is saying, we think this should be precedential versus we would like to investigate whether this should be precedential. And it may not make a lot of difference, to the non-lawyers, but there's a significant legal, as you're sitting as a quasi-judge, as the final agency decision maker. And certainly, we'd be happy if you made a recommendation to explore whether it should be a precedent decision, to come back, to research that, to meet with staff, and then come back and make a recommendation to you. And then,
It is that type of procedure and policy that I think needs to be really vetted for this committee, for the appeals committee. And quite frankly, that's something that I ask you, would those types of rules have to come through the governance committee, or could those rules be rules of the appeals committee based on the changes to the charter that the governance committee is ultimately approves?
so you would put in the policy itself, upon recommendation from the Assistant General Counsel. I don't think that needs to change, because if I'm asked to investigate whether, or if the Assistant General Counsel is asked to investigate whether a decision should be made precedent and make a recommendation, then that would be covered by this policy as written. I don't think you would need to change it. Anyone can come to me, any member, and anyone could say, well, I like this decision. I wonder if it should be a precedent. And then it would be up to the Assistant General Counsel to do the research, to meet with the staff, and then make the recommendation.
And Michael, if I may, I'm sorry,
Please.
John, to interrupt, and I interrupted you as well, I'm sorry. But I wanted to answer your question, is that if the charter is approved, the charter change is approved and the authority is delegated to the appeals committee, yes, the policy on how the appeals committee does this stuff would be within their, the ambit of their responsibility. So, yes, sort of fine tuning the policy could be something that the appeals committee could do over time, as long as they're delegated the authority. Sorry, John.
Ms. Hendricks?
Yeah, John, I think your explanation of what our role is on the appeals committee, I feel like I have a lot of clarity. So I know, to me, your explanation makes complete sense, and I feel like you answered my questions directly. So I feel comfortable with us moving forward with some of the edits that Dana and kind of suggested. So I just wanted to say that.
Michelle?
I was just thinking about Dana's question about asking for information, and from the cases that we hear, I would see more often than not our request for staff to look into whether or not we could find a precedential case would come from a case that we'd hear where the ALJ went completely, left field of what we're used to seeing on a particular issue, and so we wouldn't necessarily have the precedential decision to decide on at that moment, but maybe that would be a good time to ask for that research. So I would see that be more of the entry point of our requesting for that kind of research.
And I can assure you, we have seen this, the similar facts in law, and we deal with 4 courts. We deal with here in Sacramento, Oakland, Los Angeles, and San Diego. So we have 4 different pools of judges, so we don't always get the same judge. If you can draw the analogy into federal court, you get the 11th Circuit versus the 9th Circuit. So it's something similar like that. This would apply to all the ALJs and all the offices.
Thank you, Mr. Chair. So the question I had is, the way this is written, does it bind the appeals committee to necessarily have to send it back for your review and then to come back? Is there a situation where the committee would just want to decide in the context of a particular case that it is precedential? Or would the committee always want to refer it back?
It would be agendized.
I do think you can answer. And again, John, I'm sorry I interrupted. Yeah, there is a role for legal advice on adopting a precedential decision, that there are, I think I heard it mentioned before, unintended consequences. It is a very precise tool. So certainly the appeals committee, and they have in the past, and they will in the future, express their opinion and recommendation and direct staff to do what's necessary to move the appeals committee forward. But it would be, it's sort of as the board's advisor, as opposed to the systems advisor, and the board the appeals committee has its own counsel. My recommendation would be, yeah, let a lawyer analyze it and bring it to you, and then make a decision. Just for the process, even though sometimes it may be pretty clear. I mean, the appeals committee members have seen enough cases to get to your point, Richard, to say, yeah, this is a duck. Absolutely, it quacks. It looks like a duck. The other point to what Michelle said, I do think that you're right. The entree to this process may very well be the appeals committee, but I have to tell you, if it's a really good decision, it may be John or his staff running into the meeting saying, look at this, we've got this, it's very clear, it's finally clear to the members, and could we please analyze this? So I do think that, it'll come in from all different ways, but I would hate for us to go forward without having some legal analysis and legal advice. And then you have your own counsel as the appeals committee who could then filter the advice that you're getting from the systems attorney. And that maintains that ethical wall for us internally in the legal office.
Thank you.
Thank you. So,
Can I just follow?
Please.
And I know for the members of the appeals committee, Chris Waddell currently advises them. It's because under the law, I can't advocate for an outcome and then advise you on what the law is. It's an ethical issue, and that's why Brian had my job previously. We're getting rid of most of those cases, but if any of them were on the books at the time, that's why he's not allowed to do that in that capacity on the appeals committee.
So I think what I'm hearing is a general consensus for the policy as written, with the possible exception of the deletion of the term expeditiously.
Yeah.
I would entertain a motion to amend the policy to delete the term expeditiously from item number 2. Under responsibilities.
And that's on the charter. That's on
on the charter,
Board
correct.
Governance 56, item 2. It would read to hear, deliberate upon, and to designate all or part of a administrative law.
You deliberate upon and decide to designate.
Right.
Is there a motion to amend it? I think it's just the 3 of us.
Oh, so moved, or move to approve? Do I have to say move to approve?
You're a second?
Oh.
Second.
Dana, you had a comment?
If Sharon wants to speak to her motion, I'm good.
No.
Okay.
Okay.
So Nancy, through the chair, if I could, how, I'd like you to weigh in on just removing expeditiously, if that allays your concerns.
I dropped you again somehow.
That's okay, I got it.
Yeah, I think that's fine. I just didn't want you to be seen as not living up to your policy. We could either drop the term expeditiously, or back to Michael's point about if it's brought up by the Assistant General Counsel, then you should be expeditious. But quite frankly, I think you can or can't, whatever you want to do. I did have a question. Do you want to leave the index being updated? This is on page 53. The index being updated not less frequently than annually. I think there's a typo there. It should say than annually instead of that annually. Do you want that to be promptly rather than, the index shall be updated promptly? I just,
I'm fine with no less annually.
okay.
It should be done promptly, but no less annually in terms of,
That's what the law says.
yeah. There's a motion on the table. All in favor?
Aye.
Aye. So now entertain a motion to approve the to approve, I'm sorry, yes?
So it would be both for the charter and the addition to the board policy manual, the charter removing the word expeditiously, and the board policy manual just making that change from that to than. Okay.
So that's been approved, so, so now we need a motion to approve it as amended? No, we just amended it,
Move to approve.
yeah. I'm sorry, go ahead.
The recommendation was, as you agree on the language, then the recommendation is to take it to the full board for adoption of the policy as well as the, as amended, as well as the charter as amended.
So that's the motion?
So we still need a second.
Still,
So I
a
second.
second, all in favor?
Aye.
Of course, aye, so. We're done. Dana, did you have another comment?
That doesn't, I mean, the language that's currently in the policy, unless there have been no precedential decisions designated since the last update. So it won't be necessarily updated, but we will, this doesn't preclude us from putting, this was reviewed, last reviewed on, or whatever. Okay, thank you.
And that's
I think that's important.
And that's something we can work with the committee on. We give you an annual update, I believe in September. It's whatever date you pick.
All right, excellent, thank you,
Mr. Chair, could we take a quick break before we do this next one,
certainly.
please? Just real quick.
Like 5
5 minutes? Is that enough?
Give me-